Hello and welcome to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you may have, and I will share them with Hector. Second, if you experience any technical difficulties today, please let us know in that same questions tool, and we will do our best to resolve them. And finally, just to note, the recording of this session and the slides will be shared via email in the coming days. So without further ado, I'd like to hand over to Hector to get us started.
Thank you very much. So welcome to this webinar. Thank you very much for joining, and I hope you will get insightful information on the Mexican patent system, given the changes that we faced, or we are facing actually under the new law enactment. So again, thank you very much for your interest, and thank you very much for being here. So we'll start with the presentation right now. So the idea is to cover certain topics. Of course, it would be very long if we entered into much detail in every aspect of the changes in the law. But I divided the presentation in three main topics. The first one is, what are the key changes in the substantive patentability requirements? What are the impacts that we are facing at this point in managing the prosecution of patent portfolios in Mexico? And finally, the litigation setting, given some changes also that we've been seeing or that happened under the new law. So just for you to know, the new law entered into force November 5th last year. So we have only a few months under the new law. And of course, although the regulations are supposed to be at this point enacted, they are still under discussion, and we don't know really when they will be issued. So as a transitional measure, the former regulations of the prior law are still in force at this point. Now, I want to start with some very key points on or facts about patents in Mexico. First, 94% of the filings in Mexico are foreign filings. This means that only around 6% of the patents filed in Mexico belong to Mexican entities. So Mexico is very much a market of interest for foreign companies, and this means that the quality of the patents filed in Mexico is a little above, because typically patents filed in Mexico are only those that matter from the market perspective. So this is why we have only 17,000 patents per year filed. And one other point for you to take, which might have very surprising, is that around 50% of those patents are filed by very much 4 or 5 firms at most. So and I'm going to explain a little bit more about why along the presentation. So what are the changes regarding substantive issues on patentability? Well, not so much change in the patentability principles, which is good, of course, because that means that we are still under an international standard of compliance with international treaties and the general international practice on patents. So on the general principles, the definitions are consistent with international patents regarding novelty, inventive step, industrial applicability. There is a new language which we find odd because the intention of the changes in the law was to make it clear that new uses of known compounds are patentable, but they decided to carve them out from the prior art instead of getting a more straightforward provision. So now we have an odd language, I say here, which establishes that when you are claiming a novel use of a known compound, that compound will not be considered part of a prior art. So again, a bit odd, but that's the way they found to make this clear that new uses are patentable. Now, in terms of the claims definition, there are some changes on the language for they changed the language that used to refer to essential features in the definition of the claim, and now they are moving to a language that is related to claim rights, and then the essential technical feature, so to speak, definition is set forth only as the content of the claim, but not as the definition of the claim. So again, this is not expected to be a change, but it is a change in language only. Well, what is really new is that double patenting has been prohibited for defense of the public domain. That's which is again something a bit odd in terms of the language, but the real thing is that now expressly the law includes a provision that prohibits double patenting per se. So it is one of the criteria that we develop, and I will talk about more in depth later on this when I talk about divisional applications. Now, in terms of biotechnology, the main changes relate to some exceptions that have to do with ethics, scientific ethics related to human or animal genetic materials or experiments. So it has to be with stem cells and some of these technologies. You have to be careful on some ethical implications that are included now in the law. And also there are changes regarding the definitions, particularly for plants patenting, in terms of the definition of what is essentially biological and whether plants can be claimed as such or not. The criteria will evolve with time. The position of the patent office at this point was that plants without or coming from crossbreeding process were not patentable, but the new language we think opens some possibilities for patenting this kind of plants, although the arguments and the claims will have to be fashioned under the new wording of the law. Now, in terms of another important area, which is computer implemented inventions, that includes, of course, Internet of Things related patents and blockchain, etc. The prohibition to patent computer programs, which was already in the law, and along with other such as the mathematical methods, which was also a prohibition for considering an invention. We're not considering inventions under the former law. All this article included an addition that says that this will not be patentable only when claimed as such. So we are interpreting and in the patent system that this will eventually allow to include this kind of inventions as a part of the let's say as a part of the claim as a technical feature, but it seems that in practice the Mexican Patent Office is not interpreting the same. So still there's going to be some shaping. These kind of inventions are patentable in Mexico under certain language considerations, avoiding precisely language directed expressly to computer programs or by adapting the claims to computing means or processing and configurations. So these are expected to be kept patentable, but there might be some changes in the language for the claims according to these changes in the law. Now, in terms of the pharmaceutical industry, as I said, second uses of known compounds are now more expressly patentable, even though they existed already, and there are not expectations to change the practice. Currently, the Patent Office accepts EPC style claims and Swiss style claims, so these are expected to be still allowed in Mexico. The TRIPS prohibitions regarding methods of treatment are kept, and there are other provisions related to linkage of the sanitary registrations and patents that will remain under discussion for formulation or second medical use patents, and I will go more in depth later on this. And there is a new exception to enforcement of patents for regulatory use, which intends to include expressly in the patent law Roche-Bohler exemption kind directly. So this is perhaps the most significant issue on that side. Now, that's on the substantive issues. Now, I think that the main changes are related to patent prosecution particularly, and there are many challenges that are related to patent prosecution, which I will address at this point. Now, first, I'd like to provide some help or guidance in terms of selecting a firm. I'm currently not doing patent prosecution. I did that for a while in my former firm as the head of the patent prosecution department, and I did literally thousands of filings, and I know that sometimes it's difficult to get an idea on how IP firms work in Mexico. So the first thing you should know is that there's no patent registry for patent agents or attorneys in Mexico. So basically, or virtually anyone can file a patent in Mexico. If you are a resident, if you, of course, have the ability to be a representative in Mexico legally under general law, then you can do it. Of course, you cannot do it if you are a foreign resident. That's the only requirement we have. But most firms in Mexico that advertise intellectual property services or industrial property services do not have technical background staff or staff with technical background. So there have been cases, very, very sad cases, where poor prosecution has led to put at risk whole patent portfolios. And the selection of the firm is a very important issue to take into consideration. So when you are selecting a firm, I would tell that an effective firm will have timely response since the moment of the filing. It will a good firm will have good reputation with peers and clients. They will have probably a patent attorney, and I will go more in depth on this. But they will definitely have strong technical staff within the firm, and they will have safe and reliable docketing systems. These are the features, or the main features, of a good firm in Mexico. You're probably at risk, and you will want to review your firm selection in terms of only if you are relying on the good marketing, or if you are detecting that they have only attorneys at law or little prosecution experience in terms of the filings they do per year. You might want to revise that. Now, in addition, the problem of conflict of interest is one that you want to look at it carefully. You cannot be very strict because, as I said, there are only really 4 big firms that file almost half of the patents in Mexico. So the probability of conflict of interest is very high. So you would like to look at, probably independently through an independent study, who is filing on behalf of your competitors, so you can make a better choice on the firm that you are using at this point. Now, on the patent attorney issue, again, because there is no patent registry for agents really in Mexico, then what you can have in few firms at this point is people with a technical or science degree that also is an attorney at law. and are trained in-house in the firms for patent law. So when you hear that there are patent attorneys in a firm in Mexico, you should look at this feature. They should have a science or technical degree and a law degree, of course, as in any other jurisdiction, but particularly otherwise you will be dealing with a firm that will have the equivalent of a patent agent. There are very skilled patent agents in several firms in Mexico that can handle patents, of course, but you would like to look at that experience on the patent agent or whether they have a patent attorney. Typically, someone that has a law degree and has been for some years in the patent practice, and you might be able to rely on this kind of professional. Now, there is a lot of confusion in terms of applicable law because of the position that the Mexican Patent Office is taking. One problem is that the transitional articles in the law are poorly drafted, and the new law is applicable only to new applications. And there was not an opt-in for the new law in the transitional provisions. So the problem is that all the patent applications that were filed before November 5th last year are supposed to be treated under the former law, which is the industrial property law, and the new law is only applicable as of November 5th. Now, what is the problem? That under the PCT, an international filing date is their filing date in all of the designated countries. And that, of course, includes Mexico. So the current interpretation is that any national stage filed after November 5th is prosecuted under the new law, which is not necessarily what it should be done, because we need to consider that the actual filing date for legal purposes, even for the computation of the term of the patent, is the international filing date. So this might have an impact in some sensitive cases, and on a case-by-case basis, you would want to look at this with your firm, because this is going to be something that might be problematic in the following months or years. Now, the most critical issue at this point is that divisional applications are being considered on the new law, under the new law. And this has a lot of implications that I will address in a few seconds. My first recommendation on this is to ask your firm to argue upfront at filing or when replying to an office action if you think that this is going to be an issue, and your firm thinks that there are differences between the effect that will have applying one law or the other, because that it falls into a point of conflict. Then you want to do it up front, because this will difficult a fast decision by IMPI. IMPI is taking very little time to address whether one law or the other should be applied, and they are just handling everything in bulk. And if you upfront put a burden on IMPI to prove that you're wrong, then they will have to think of it twice, and at least to have an argument, a more solid argument on why they think that they should apply one law or the other, and to your case. So that's something to consider for you in terms of the prosecution. Now, another issue to consider at this point is e-filing. The evolution of e-filing comes from 2016, where e-filing was first available. The system opened only for filings, and then the rest of the prosecution had to be continued in paper and at the IMPI office. But since that very beginning, digital images of original documents were accepted instead of having to file the original document. So for assignments, for powers of attorney, and other documents like this, this was a very interesting tool, even if you use them only for filing, because it dropped the cost for the management of documents in that sense. Then in 2017, the system opened for full electronic prosecution only for new cases, of course. So if you had a case that was filed in paper, you had to continue it in paper. But if you started an electronic file, then prosecution could follow electronically since then. So some firms started to do electronic filings from 2017 to 18. There were some problems on the stability of the systems that prevented a faster change. But in 2018, there was another change in terms of the need of electronic systems now from the side of the firms, because substantive office actions are now notified only through the official gazette. So the firm cannot do any more going to IMPI in order to get personally the office action, which was a way of controlling the terms, particularly for response. And now all the firms have to follow up the official gazette in order to get the information on the substantive office actions, which is all office actions that are issued after publication of the patent application. So there was a significant change in 2018. And of course, the COVID pandemics had an impact, because as of 2020, in June, when the patent office opened again after the first closing when the pandemic started in Mexico, the Mexican Patent Office finally provided a means to convert from paper filing to e-prosecution. So this is currently kept also in force under the new law. And well, e-filings and submissions are signed by the representative electronically. There is an e-sign from IMPI, and also you can sign with the general or the more secure e-signature from the taxation authority, which is also possible to do at this point in IMPI. IMPI officers actually sign electronically all the communications to the applicant. Digitalized original documents are accepted, so everything seems very good, but yet IMPI is rejecting e-signed documents from foreign providers. So DocuSign and other platforms like private platforms that are used internationally is not being accepted by IMPI, which we find really incomprehensible, because everything else is being accepted, and we cannot understand why they are giving more weight to digitalization of an original document that is just put on a PDF file and uploaded to the system, than to an actual electronic firm document, electronic signature document that is actually verifiable through a platform. So even though we are discussing, or all practitioners are discussing this with IMPI, the recommendation at this point is, first, try to use digitalized physical documents. Unfortunately, this is the simplest way to go around this practice from IMPI. But when you don't have a choice because the inventory is not available, or the representative or whatever, and there is a term, and you have to file a document that is only electronically signed, then, as I said, you have to provide arguments upfront based on the Mexican Federal Civil Code, because the Mexican law and the Civil Code allows electronic means as a way to show consent of any kind, generally for any civil document, and then also provide at your upfront the means for verification, because that way the patent office will have to say why they cannot verify, and they would have to have a better foundation on their objection, which at this point is very poor. well, I have a question on how many enforcement actions are pursued each year in Mexico. I'm going to talk about it very in detail and as in the last part, which is directly addressed for litigation. So I will certainly talk about that in a few seconds, or sorry, a few minutes. And yes, we will share the slides for all attendees through the organizing through the organization. So yes, this will be of course shared. Now, in terms of the divisional applications, the situation at this point is becoming critical. Let me explain why. Firstly, the first problem is that we are having at IMPI at this point is that the new law prohibited, or not prohibited, but restricted to very exceptional cases, or as an exception, the possibility of further dividing an application that has been divided. So let's say the division of a child application is now restricted and had to be somehow justified by the applicant and the patent office. So, and also the subject matter must be different. That's the change in the law. Because there is a lot of patents under prosecution. There are a lot of patents under prosecution that are already a division of a divisional, and they are being further divided under the former law. The problem is that IMPI is having this questionable behavior that is applying retroactively the law and is rejecting all of these divisional applications from even at the stage, not of the substantive examination, sorry, but at the formalities stage. So the problem is that the former law does not regulate very clearly divisional applications. They consider only divisional applications. Our former law considers only divisional applications that are requested expressly by IMPI, and we typically in the practice, voluntary divisional applications were filed under Paris Convention provisions. And because double patenting is expressly prohibited, the criteria will be developing also, but is the basis of the rejections of the divisional applications of patents that were filed before November 5th last year. So in addition, IMPI is applying an overly narrow criteria on this because it is not being assessed by the substantive examination area at the patent office, but it is being assessed at the formalities stage. So we are having a large problem in the practice for this kind of divisional applications. So what you should or you can do if you're having this problem with your applications is that firstly you have to change your mindset regarding divisional applications in Mexico, because you will have to file all relevant divisional applications at the first division. That would be a better way to address this, so that you limit at the lowest level the division of divisional applications or child applications. Also, again, ask your firm to submit upfront arguments on the admissibility at filing of the divisional application as an additional annex to the application, because that way if you provide those upfront, the possibility of acceptance and that they will move this determination to the substantive examination area is going to increase. At this point, there have been even a lot of appeals filed by some firms because of the rejection of divisional applications of patents filed with the former law. And I would say that you would like to raise awareness with your local subsidiaries so that they help put some pressure to the patent office locally. Practitioners, we as practitioners are organized, and we are trying to talk with the authority, and also NGOs related to patents, of course, are trying to reach an agreement with IMPI for changing the criteria. but this has to be taken to your local subsidiaries if you are a multinational a firm, so that we can have as much help as possible. So patent application, have here a question that patent applications can be filed or carried out in English. You can file in English, but you have to submit a Spanish translation. So typically, if you file in English a PCT application, you will have an office action at the formalities stage, granting a term of 2 months that can be extended for further 2 months to submit the Spanish translation, but you have to. And of course, if you are filing a Paris Convention application, you will have to submit the translation of the certified copy of the priority document. And well, here's a question that if it is possible to reliably create a non-unity by adding claims during prosecution to force the patent office to request that the added claims be filed in a divisional application. Well, I would say at this point it will be risky because again, the position that IMPI is taking is very strict regarding divisional applications. But of course, and the problem we are having is that even we have some cases, limit cases where IMPI already requested the division, and then after that request, because of this asymmetry that we are having, that these are being objected at the formalities stage, even though the substantive examination area required the division, they are rejecting the division once you file it according to this questionable practice. So even though this might seem like a good way to force the patent office to request the division, it is not going to solve completely this issue. Now, I think that even I would say that if you want to file a divisional application, once we have this, I think this is only a fuss that we're having because of the change in the law and because there is this intention of IMPI to limit divisional applications. What in the end, what they are trying to avoid is Mexico, as you may know, doesn't have a continuation application format. So divisional applications are sometimes used as a kind of continuation. So that's why IMPI is going to be very strict in the double patenting, and IMPI is going to be very strict regarding subject matter that you already claim in a former divisional application that you put again in a new divisional application. So that kind of action will very straightforwardly limit. But if you provide a divisional application with subject matter that is clearly distinct from the claims that you filed, whether you had them in the record or not is not going to be that relevant, but the difference that you find and you're able to point out at filing the divisional application. So if you're able to prove that this is different subject matter, you should not be limited to file this kind of divisional application. And again, I would recommend to put upfront these arguments at filing, so that this is not done at the formalities, but at the later stage once it goes to substantive examination. Sorry, I took a bit longer on that I expected to this, but this is a very hot topic in Mexico under prosecution at this point, and I think it was important to address it. So moving forward to the next slide. These are other topics. I will not go in depth, just say that there is a new practice or there is this new figure of the complementary certificates for undue prosecution delays that was included in the law because of the USMCA commitments made by Mexico. There is a 5 years cap on the additional complementary certificate for these delays that will extend the exclusivity for the granted time. Delays by the applicant are not going to be considered. must be requested at payment of grant fees, and the patents granted only available for patents granted under the new law, of course. There is a low possibility of use of these certificates because at this point IMPI has internal procedures with examiners, and it is very rare that a patent application will go beyond 5 years in its prosecution. But there may be, of course, some cases where if you have more than 5 years in prosecution on your patent, you will have to request the certificate at the moment that you pay for the grant fees for issuing the patent. Now, also, there is a very short time for third-party observations on patentability, ex parte. It used to be 6 months the term, but it was shortened to 2 months, which is extremely short. But the reason they gave is that it was almost not used by anyone, so they decided to shorten it to 2 months only. After those 2 months, PPH can start. The patent prosecution highway is in force in Mexico for US, Japan, Spain, Korea, China, Singapore, Canada, countries in the Pacific Alliance, which include Chile, Colombia, and Peru, Portugal, and the European Patent Office. It works well except for second medical uses and computer implemented inventions which need proper drafting. So sometimes if you don't draft properly, you might get rejected the PPH, but you will get the application examined anyway. So, and regarding linkage, as I said, well, just for you to know, if you're not aware on how it works, Mexico has a system that, unlike the Orange Book, for instance, in the US, the publication of the patents is made by the Mexican Institute of Industrial Property as patent authority. It used to be based only in regulatory or in regulations, and now it was raised to law level. And there is ongoing discussions in the industry on whether formulation and second medical use patents should or should not be published in this official gazette. So there is not, at this point, it is working just the way it used to work, but a revision is ongoing, and as the regulations are issued, we might see some changes there. Now, okay, so as promised, I'm going to talk now about litigation and somehow monetization based on litigation, of course. And I think it is important to say that the former law is very different than the new law in many aspects, and probably this would need a specific webinar on the new, I would say, the new frame for litigation for patent litigation in Mexico. The former law, of course, mandated that nullity and infringement of patents were prosecuted as administrative proceedings in trial form, of course, but before the Mexican Patent Office. And then you have an administrative court instance of appeal, and then the judiciary appeal in order to get a final decision on either an infringement or a nullity action. Civil actions needed a final decision on infringement to be brought, and then, but the interesting thing is that the minimum statutory damages that a patent owner could claim were 40% of gross sales, which means based on the price to public of the infringing product. So this is a huge contingency, and I will talk about the practical implications this has rather in the litigation environment in Mexico. Now, the new law keeps the infringement and nullity of patents as administrative proceeding. There are 2 instances of appeal still the same, but now under the new law, a civil action can be initiated without an infringement declaration. And for this, marking is of the essence. So the marking of the products that are covered by a patent is going to be of the essence if you want to use this civil action. And another interesting change in the law is that formerly IMPI was not able to determine damages, but now you can go to IMPI to assess damages so that IMPI will determine. And well, the 40% rule is kept as a minimum statutory provision, but now it is based, because of the influence also of USMCA, on what is called expressly in the law as a legitimate value indicator, which can be either the market or the suggested retail price, the lost profit or the infringer's profit, an equivalent royalty if the infringer had to have a license, or the royalty of licenses that are paid actually under licenses granted by the patent holder. Now, you have to be careful here, because the 40% rule will be applied according to what the patent holder is able to prove. So if you provide as a legitimate value indicator the price, that is going to be what is supposed to be considered at least under the wording of the law. Now, just for you to have an idea on litigation in Mexico, unfortunately, we don't have any source of information that can tell us how many of the proceedings at IMPI are patent or trademark, and not even, of course, what area of technology. And I'm sorry, I'm not going to be able to put this information. But as you see here, litigation numbers are not extremely significant in Mexico. As you see, there has been an increase over the years on the nullity actions in Mexico. Infringement actions are both overall trademarks and patents are around the 400 cases, and out of those, patent cases are really a minority. It is typically 10 to, or the estimation is that typically 10 to 20% of those are patents. At most, you may have from 20 to 50 cases of patent infringement in a way. And of course, the pandemics have limited the actions at IMPI. If you look at the numbers, it is very clear that the pandemics had a negative impact in the actions brought to IMPI, and I think it is just logical, because the ability to monitor infringing activities is also restricted under the pandemics. So, and of course also the commercial activity itself is lower. So these are the figures that we can have here. Unfortunately, again, I cannot make a significant breakdown, but what I can look at is, or what I can tell is that there are some implications regarding some facts under the new law and the former law. The statutory 40% rule used to incentivize settlement, and we expect that this will continue. Why? Because having, from the infringer's perspective, or the alleged infringer's perspective, even if it is able to prove down the road that the infringement didn't exist, having a contingency this huge on gross sales in Mexico, which is also a very significant market, is not something you want to have in your statements for shareholders, or in your statements for taxation purposes, etc. So, of course, this is something that had a very important way in the dynamics in Mexico. So typically, either through prior consultations you reached an agreement or a settlement, or if litigation started after the first few months of a round at IMPI, looking at the evidence of the other party, settlement was is the norm under the 40% statutory rule, or was a norm. Now, the second is that you have to remind or remember that the 90% of the patents filed in Mexico are from foreign filers. So typically these belong to an important family. As I said, the patents filed in Mexico are typically relevant to market. So typically they will go under litigation elsewhere in the US, or there will be an equivalent in the US, in Japan, in Europe. And then if you go through litigation there, typically what you will see is that there are going to be settlements for the rest of the patent family members, and that's of course including Mexico. What I think is that not necessarily this 40% rule is considered when talking about damages in Mexico, or talking about the settlement for Mexico particularly, which should be as a strategic issue. But anyway, this is something that happens in practice. So this is why we have low numbers of litigation regarding patents in Mexico. Typically, litigation for Mexico will go for local infringers only. I mean, infringing companies in Mexico, which is mainly or the major area for litigation in Mexico in that sense is pharmaceutical, although the manufacturing for electronics is significant in Mexico. Also, automotive industry, as we move forward to other communication technologies that are going to be implemented in the car industry, it's becoming increasingly important to have patents in Mexico because of that. And well, under the former law, we had a special IP courtroom that studied all administrative appeals, which remains up to date, although there were rumors that they were going to close this room, which again, we don't want to from the IP perspective, but there is. And infringement was evaluated by the patent authority, which provided a bit of a specialization to the decisions as opposed to the decision of a judge only. And regarding the new law, the problem is that there is uncertainty on the effectiveness of the new damage rules. We will not see how that works until we start seeing the first cases, probably in the copyrights or trademarks arena. Civil courts lack experience in patent litigation, and IMPI lacks experience in determining damages. So again, how this will work eventually is something that until we have the litigation cases, we will not be able to see. But we think that it will be good that you can start the damages at the civil stage, so that when you have a first hint on IMPI, you can accelerate the prosecution of the infringement cases, and that's something that we expect to become faster in terms of the procedures. So so this is on the litigation arena what I can share with you at this point. The recommendations would be, of course, file in Mexico. Why? Because it is a significant market. Again, as I said, the provisions on damages are significant, and this even for the sake of patent pooling, for instance, if we are talking about telecom or other areas where you have a significant volume of patents, it is interesting to have a patent in Mexico for that matter. Also, you want to do a freedom to operate analysis in Mexico, because again of the fact that the quality of the patents filed in Mexico is not it's not low, because they are filed only those that matter for the market. And if you initiate an infringement action, you'd like to get proof of legitimate value based on pricing, and also for your licensing contracts, you would like to agree in the licensing contract that the legitimate value in case of breach of the agreement later is the sorry, the market, or even better, as it used to be, the selling price to public, as you can up or level up the standard to the 40% minimum at that point. Now, do remember that this is a minimum statutory 40%. So if you are going to use a different legitimate value, then you can request for, of course, more percentage, even 100%. Of course, if you are going to talk about a royalty, it is not, of course, consistent with the 40% rule, because you would be having only 40% of the royalty that you are supposed to be paid. So also from the defensive point of view, you will want to address and to attack the patent holder by saying that the legitimate value is not the one that is chosen by the patent owner, but a different one. But it has to be proven also. So in terms of damages, I think this we're going to be facing the major changes, and unfortunately, we will not know probably soon until we have the first cases coming up. And again, perhaps this will be established sooner for copyrights or trademarks rather than patents. But whatever is developed in that arena will affect patent litigation, of course. So this is it. We wanted to make it short, so I'll be glad to get any questions, additional questions you may have. Again, I'd like to thank you also again for being here, for your interest in this webinar. And well, if you have further questions, please do not hesitate to put them at the platform. Or sorry, I'm seeing here some other questions I didn't address. So if the Mexican Patent Office forces the applicant to divide the claims, what reasons are they giving for refusing these applications? Well, the problem is, again, they're not giving many reasons, because this is being done at the formalities stage. So again, that's why, and I totally agree with this comment that what authority they are citing to refute their own requirement for restriction. They're not even citing anything. They're just saying that you cannot file this because of the new law. This is again against the law. So they are applying it retroactively, which is unlawful, of course. They are not referring to that again. So the strategies by the firms are very different. Some firms are providing or are asking the clients to or recommending the clients to file for appeals, so that this wouldn't affect the application going forward, which has to be done for very relevant divisional applications containing very important subject matter. But my recommendation is, precisely because of this, that these arguments are provided up front by saying at the filing in an annex that this application is being filed because of a request by the Patent Office, firstly, and that secondly, that the applicable law should be the one that should be applied, and the justification on why this is timely filed, because we start seeing cases where they are saying that because of this change in law and etc., then they are questioning whether, particularly for applications filed not in response to the office action or not in the before the notice of allowance, or I mean, when they are filed in between the notice of allowance and the payment, they used to be accepted under the former law, actually, but they are now using that argument to reject them. So we don't know why IMPI is taking this position. Actually, it is really incomprehensible. But my advice is, ask your firm to provide these arguments up front, so that when it comes to the formalities section, they will find it more difficult to decide on their own, and this might move forward at least to the substantive examination issue. And also, then you will make it apparent, and they will have to justify more in depth. And even if you have to go to an appeal, you will have more arguments to get a rapid or a faster decision on your appeal if you have to do it. This is really shouldn't be happening, but this is very unfortunate regarding the handling of divisional applications at this point by the Patent Office. What's the percentage of pharma and biologic patents that are filing in Mexico respect to the total filings? Yeah, well, I cannot file or sorry present this but I know I mean from my experience that it is around 40% of the patents belong to biotech or pharma somehow, and then the rest is significantly on the electronics of course side of technical area. So it is a significant portion of what is filed in Mexico, the pharmaceutical and the biotechnology patents at this point. So I have here more questions. So what would be the Rigoberto asks what would be the typical consulting cost of prosecution or a patent or industrial design in Mexico range? Well, in my experience, you can find an offer from probably even 400 talking about just filing. We're going to go from 400 to 1200 US dollars for filing. But again, please remember what I told you, that there is not a registry for patent agents in Mexico. So probably if you are getting a lower price, you're not getting necessarily the service you will want. So I would say that the market price should be around 600 and 900 US dollars for filing. Overall, through all prosecution, you may want to budget, depending on for biotechnology and chemical inventions, they typically go with more office actions in terms of sometimes you have method of treatment claims, sometimes you have more objections related, so and typically are a little bit more complex. So probably you would want to have a budget for 4 office actions that probably would go from $5,000 to $5,000 to $10,000 overall if you go to the 4 office actions. But typically, I think that you would be good if you budget around $6,000 for the whole prosecution. This is, of course, without maintenance. I have another question here. Can method of use patents, for instance, the use of certain compound to treat certain disease, enforced against a non-authorized drug manufacturer distributor? Okay, regarding enforcement, I would say that you have two issues here. I would recommend to try to use EPC style claims, because these are considered from the subject matter perspective directly a product claim. So if you have a product claim and the issue here is that the non-authorized drug manufacturer or distributor has to have in the label the claim of the second use. There are some times that you don't have in the label this use. If you don't have it, it will be very difficult to enforce. But if you do have by this non-authorized manufacturer this second use claimed in the label information at register, then you have good chances to have this patent enforced against this infringer in Mexico. In addition, under the new law, the wording was changed because the problem with method of use, in particular with Swiss style claims, you had a poor language in terms of the infringement causes as recited in the law. And the new law changed this, and now it does include the possibility that you can claim against an invention. Formerly, the law referred to product or process. And then if you had a claim that the use to manufacture, which is the Swiss claim style, you had difficulties in getting a straightforward cause of infringement. You had to go to other causes. but now it refers to an invention, and because an invention can be used, then you are in better shape to enforce actually these kind of patents in Mexico now, because you have a straight cost for infringement. So I think in this sense, the new law is better in order to justify the infringement of a second use or a method. It's not a method of use. Again, it is an EPC or a Swiss style. Method of use, straightforward or not allowable in Mexico, because we have the TRIPS exception that prohibits the patenting of therapeutic methods particularly. But if you have an EPC or a Swiss style, then you certainly can enforce it against a manufacturer with the regulatory approval in Mexico. Of course, we want this to be in the linkage system. So if we are able to include a formulation and particularly second medical uses in the linkage gazette, then you will have also an inhibition of the grant of the approval of the manufacturer with this claim of use. So that's also another issue of why it is important to follow the discussions on second medical uses in the linkage gazette in Mexico. So can I cite any recent pharmaceutical case on double patenting? No, unfortunately, double patenting was only enacted under the new law, as I said, in November. Objections on divisional applications are being issued under regular prosecution in terms of double patenting. Particularly, it is again important in order to avoid double patenting objections. They are very much automatically made when you have, let's say, not a clear distinction between the claims that you already have in one application, and then your divisional application includes almost the same subject matter. So the subject matter will have to be significantly different in terms of the fact that you are claiming that, for instance, a different compound, different process conditions, different features. So you can defend that you have different cases. But in terms of cases that will go to litigation, I think we are still not there in terms of the timing. I would expect those to be, I mean, you have almost 4 months, and then you will have more office actions. So I think that it's going to be a year before we can have actually some case going to an appeal, and then the case resolved. It's going to be 1 or 2 years, I think. At this point, we only have the arguments by the patent office and what you can build in order to respond to the patent office. Again, at this point, the recommendation is try to be careful on what you claim in your divisional application, and also try to put forward very clear arguments when you respond, almost as if you were already litigating in an appeal, because this will prepare better your appeal if you need to have an appeal against the patent office. That would be also, I mean, my response to this other question. So it seems, or I think I addressed all the questions so far. Yeah, I think this is the last one. So I don't know if you have any other questions, please feel free. Otherwise, of course, please feel free to contact me if you want an advice, of if you want me to help you out with some of the cases you are receiving for your firm. Again, as I said, I'm more focused now on the strategic insights of patent prosecution and the management of the portfolios. So if you want an opinion on what you are looking at in your cases, please let me know. And of course, well, I don't know if you don't have any more questions. We'll be closing the session. When do I expect the new linkage relations will be issued? Well, I know they are under discussion at this point. They should have issued already 6 months later, or 6 months after the even the publication of the law. This didn't happen, of course. So at this point, it is very uncertain. I would say, given the timing, we could expect it this year, probably around the anniversary of the entry into force of the law, which I think is the day that they will choose, not only for linkage but for all the regulations of the new law. But this is only a speculation. I really can't give you I would say an informed approach on when this will be expected to issue. Another question is, are cease and desist letters, warning letters common in Mexico? Yes, very much. They are very common, and as I said, even sometimes they don't even reach Mexico. Sometimes they are managed at corporate level, and again, because of the risk, sometimes there is an early settlement, or even if there is a very straightforward non-infringement, it is also settled very straightforwardly. So they are used in Mexico. Of course, you have to be very careful, strategically speaking, on what you say or not in the cease and desist. Of course, there is also the issue when you already or when you have an infringer and you don't have your patent granted. There are sensitive issues there on the cease and desist letter, but they are very common and they are used regularly. You just have to be careful on the wording and on the objective of the cease and desist letter for Mexico. And of course, if you are dealing with a Mexican infringer, then before you engage in a cease and desist letter, you will want to really understand the profile of the company, whether it is a company that typically does not engage in doubtful, unlawful competition activities, or whether it does. And then based on that, you may decide what is best, whether going to a cease and desist or going directly or straightforwardly to an infringement action. So, but this is why also the settlements are reached early also in Mexico, again, because when you see that you have a risk and you do have a weak position in terms of the infringement, you will probably don't want to go all the way. Patent term adjustments. There's another question on patents issued before the new laws. As I said, they are supposed not to be applicable to patents that were filed before the enactment of the new law. They are supposed to be only for the new law, and this is, again, goes to the transitional. You don't have an opt-in option as in other law changes that we faced in Mexico. There were sometimes mechanisms where you could actually decide voluntarily to be bound by the new law. In this case, this is not the case. Because the new law is clear that all the patent applications that were filed before are going to be prosecuted under the former law, this is not applicable. Now, that said, you might argue later, if you have a significant delay in a patent application in particular, you would want to explore whether this is something inequitable, and there might be probably an avenue for appeal, so that you could say that this it is somehow against your rights, fundamental rights, that you don't have this opportunity that is available to other patent holders. So this asymmetry between patent holders can be the basis of an appeal against this non-application of the certificates. but I think that you would need to have a significant patent with a significant delay in order to make this worthy. Okay, so thank you very much for your questions. I think they were very good and a good number of questions. I don't know if someone else has any comments or questions. Please do so. Otherwise, I think we could be at the end of the webinar. I'd like again to thank you for being here, for your trust and your questions, interest. So thank you very much for all your attention.